brought to us. Thank you.
Thank you very
Ngā
much.
mihi. Our next submitter is Gail Pacheco.
Yeah.
No mai haramai, the time is yours and there'll be questions to follow.
Thank you. Tēnā koutou katoa. Thank you for the opportunity to speak to the committee today. I'm Professor Gail Pacheco, the Equal Employment Opportunities Commissioner at the New Zealand Human Rights Commission, Te Kahui Tika Tangata, New Zealand's national human rights institution. And with me I have Oliver Christeller, my senior advisor at the Commission. We'll take our submission as read and use our time today to speak to some of the key points I want to iterate, and hopefully leaving some time for some questions at the end. I know it's already been said today, but I want to start with noting that in the absence of a conventional parliamentary process, we recognise and appreciate the setup of the People's Select Committee and its proactive approach to seeking evidence and perspectives on the recent amendment to the Equal Pay Act. Our appearance today is under our mandate to promote and protect human rights in Aotearoa and the human rights dimensions of Te Tiriti o Waitangi. I have 6 key issues I wish to raise. I had to number them. I'm an economist. I like my numbers. So the first of these is that the 2025 amendments undermine human rights. Equal pay for work of equal value is a fundamental human right. It was recognized more than 100 years ago in the Treaty of Versailles and is included in the Universal Declaration of Human Rights and the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. The recent amendments appear to be inconsistent also with Article 2 of the International Covenant on Economic, Social and Cultural Rights. Article 2 provides that state parties shall undertake steps within their maximum available resources with a view to progressively achieving full realization of these rights. Such progress must be carefully protected against retrogression. That is, New Zealand is obligated and has committed to doing what it can to advance pay equity and is obliged not to backslide on this right. The second point is that the amendments restrict access to effective remedy. The right to access an effective remedy is a fundamental principle in human rights. Remedies must be accessible, effective, and capable of leading to redress. Collectively, the amendments have a serious adverse impact on access to remedies for breach of the right of equal pay for work of equal value. For example, the cancellation of 33 active pay equity claims significantly impedes access to remedy. In addition, review mechanisms previously agreed have been removed, thus eliminating not only a remedy previously provided for in the Act, but a remedy that was agreed between parties as part of resolving a claim. Furthermore, increasing the threshold for pursuing a claim from arguable to having merit and increasing the female workforce threshold from 60 to 70% both have the effect of making pay equity settlement harder to access. For some of these changes, they may remove access to the remedy entirely. So, for example, the Ministry of Education has reported that 64% of secondary teachers are women. So under this new threshold, their claim will not proceed. The third point I'd like to make is the importance of a robust pay equity process. The 2020 amendments introduced a process for people working in female-dominated professions to address underpayment due to systemic sex-based discrimination and historic undervaluation of female-dominated work. The process was designed to be robust and accessible with a low threshold to raising a claim. And by May 2023, 10 settlements had been reached, correcting pay for over 111,000 people, with pay correction averaging around 32%. More than 200,000 workers were subject to further claims. This process could, of course, have been strengthened further. For example, there are credible reports of workers having their hours reduced and workloads increasing following pay corrections. But instead of building on the overall success of the 2020 process, the amendments dismantle key features of the system. The fourth point is on the role of Te Tiriti o Waitangi. Te Tiriti is our unique statement on human rights in Aotearoa. It belongs to and is a source of rights for all people in New Zealand. Article 3 of Te Tiriti not only guarantees Māori freedom from discrimination, but also obliges the Crown to positively promote equity. Stakeholders have expressed real concerns that the 2025 amendments will disproportionately affect wahine Māori and make it harder for them to pursue claims. And if correct, the amendments appear to be in breach of the Crown's obligations under Te Tiriti. Additionally, the principle of partnership requires the Crown to consult and partner with Māori genuinely, and the failure to involve Māori in consultation regarding the amendments again appears to be a breach of its obligation. The fifth point, and this is quite an important point I'd like to make, is on comparators. The ability to identify an appropriate comparator is at the absolute core of a pay equity claim. Pay equity means providing equal pay for work of equal value, even if the work looks very different. To do so, we compare the skill, the responsibility, the conditions, the effort required to perform, and that opens the door for a rational assessment of undervaluation. The amendments now impose a rigid comparator hierarchy. Employers first, then similar employers, then the same sector or industry. There's also no mechanism to move to a more flexible approach in assessing value if there's no comparator within your industry or sector. And the 2025 amendments provide that when an employer decides that no appropriate comparators are available for selection, the employer can give notice to discontinue the pay equity claim with certain rights of challenge to the claimants. In sectors that are female-dominated, like education, there may be few, if any, appropriate male comparators. These restrictions risk making it difficult to pursue a claim and make it significantly more challenging for example, the 90,000 workers covered by the discontinued teachers' claim. And that's for them to realize their human right to equal pay for work of equal value. The sixth and final point I want to make today is about the use of urgency undermining democratic participation. Consultation with affected people and participation by them are recognized as core to a human rights-based approach. Such an approach is aimed at eliminating discrimination, promoting democracy, and the legitimacy of public institutions, something that a few of the presenters have already talked about today. The bill was introduced and passed under urgency. The process excluded workers, their unions, employers, Māori organisations, women's groups, and pay equity experts from the process. The human rights analysis contained in the cabinet paper relating to the amendments have been completely redacted, despite requests for this to be released. Not only do the outcomes of the Act raise human rights concerns, but so does the process. And as often is the case, one begets the other. So in conclusion, we recommend that the 2025 amendments be repealed, all discontinued claims and review processes be reinstated, and any future changes to the Act be developed through full consultation with the public, affected groups, Māori, and experts. The 2025 amendments reverse decades of hard-fought progress on pay equity, undermine democratic participation, and are inconsistent with Te Tiriti and international human rights obligations. Future changes must aim to advance, not undermine, the human right for equal pay for work of equal value.
Thank you very much for your submission. Can I kick off the questions with regards to the last point you made about the human rights section being rejected from the cabinet paper? How many times has this happened, and is it, in your view, a justifiable rejection?
Well, we've asked for that redaction to be released. We did it through an OIA process, and we got a response back that they wouldn't release it, that it wasn't and the, I can't remember the exact words they used.
It was redacted by legal privilege, and so it's obviously, I suppose I would only add, it's very hard to make an assessment of whether or not that redaction is justified without reading it, so it's sort of a catch-22.
And if you think about the public interest in this, given the amount of people that are covered by discontinued claims and future claims, the public interest is very high in this. We're progressing this through to the Ombudsman as well.
Jackie Blue?
Yep. Kia ora, Gail. Thank you for your submission. Has the Human Rights Commission considered applying to the courts to find that the current Act is inconsistent with the New Zealand Bill of Rights, or looked at going to international treaty bodies who we have treaties with?
Yeah, so we're in the process of looking at international accountability mechanisms, and we'll do that also through our international reporting system. So, for example, this year we've got the Convention on the Elimination of Racial Discrimination, CERD. I mean, I'd like to also note there, you know, in terms of one of the key mechanisms, the CEDAW, the Convention on the Elimination of Discrimination Against Women, which the last review happened quite recently in 2023-2024. In the 2023 report by the government itself hailed the pay equity system as, I can't remember the exact wording, but hailed it as an outstanding piece in our work.
One more brief question. Thank you, Steve.
Thank you, Gail. It was a very important submission. But with the depth and the breadth of your connections, had you ever examined the coalition agreement? Were you aware of this, what we now see as Project 10? Were any of us aware that this may have been embedded in the coalition agreement?
No. That's the easy answer, no. No, I found at the same time, and also if you look at the Human Rights Act in terms of the role, the EEO Commissioner role is EEO Commissioner with pay equity, and my role is, according to the Human Rights Act, to lead discussions on matters of equal employment opportunities and pay equity, and to work with other government and other parties on equal employment opportunities and pay equity. That's in the Human Rights Act. But no, I was not aware of it.
Thank you very much for your submission, and we will take a short break. I will ask that members come back to the table at 10:27, so that's a 2-minute break. And we'll be back at 10:27 to commence our hearing at 10:28. Kia ora.